On May 27, 2023, the Dolphin Emulator Foundation announced that the Steam release for their Dolphin Emulator would be indefinitely postponed. The reason cited for this postponement, as per the Dolphin website, was this: we, meaning Dolphin, were notified by Valve that Nintendo has issued a cease and desist, citing the DMCA against Dolphin's Steam page, and have removed Dolphin from Steam until the matter is settled. On the surface, the matter appears straightforward. Dolphin is making something that Nintendo doesn't like, an emulator, and Dolphin wants Valve to distribute their emulator via Valve's distribution platform, Steam. Nintendo, in response, issues a cease and desist pursuant to the Digital Millennium Copyright Act to take down the emulator, and Valve complies. However, despite how straightforward this may all seem, the reality is complicated. Let me take you on a journey, a magical journey of corporate law, intellectual property law, business ethics, and corporate governance. I'm sure that sounds miserable, but I think you'll be surprised by what you learn. And by the end of the video, I hope to leave you both with a comprehensive understanding of the legality of emulation and some insight into the careful ways that large companies in the gaming space do business. But first, a word from our returning sponsor, Brilliant. Like any good lawyer, I have a love-hate relationship with productivity. I love how being productive makes me feel, but I hate how exhausting it can be to always grind for productivity. Brilliant is great for me because it combines the most productive, self-enriching activity of all, learning, with bite-sized, interactive lessons that are fun and low pressure. Brilliant teaches you complicated topics like math, programming, data analysis, and engineering with only 15 minutes of interactive problem-solving a day. Regardless of your skill level, Brilliant customizes content to fit your needs so that you can learn at your own pace, which is great for busy professionals like myself. And with new content released monthly, there is always something new to learn. You can try Brilliant yourself by visiting brilliant.org/moonchannel. My viewers will get a 30-day free trial, and the first 200 of you who sign up with my link will receive 20% off their annual subscription. And hey, if you know me, you know I'm all about that low-pressure, wholesome learning experience. And that is exactly what Brilliant provides. So why be merely bright when you could be brilliant? Our story is a tale of two companies, but of three actors. On one side of the field, we have Nintendo, a massive publicly owned company, which possesses some of the world's most valuable intellectual properties. And on the other side of the field, we have Valve, a privately owned company responsible for Half-Life and its derivatives, the Steam Deck, and the largest digital distribution platform for PC gaming, Steam. Caught in between these two behemoths is the Dolphin Emulator project. Dolphin is, as we stated, an emulator. It's software that can mimic the capabilities of a video game console. In this case, Dolphin emulates or reproduces the Nintendo GameCube and Wii consoles, allowing one to play GameCube games or Wii games generally in the form of digital copies of said games called ROMs, which is short for read-only memory. The Dolphin Emulator project has been developing their emulator for the past 20 years. Development has been slow but very steady, and at present, the Dolphin Emulator is arguably more capable than the original consoles it emulates. For example, the GameCube and Wii consoles only support up to a 480p resolution. Dolphin, however, like most emulators, allows for arbitrary resolution, and as such, if higher resolution textures are modded into a game, you can play games originally designed for 480p in whatever resolution you'd like. Dolphin also supports spatial anti-aliasing, anisotropic filtering, and a host of other neat features. Despite its complexity, however, the Dolphin Emulator is completely free to download and use. The Dolphin Emulator project is completely open source and has over 200 contributors as per Dolphin's own FAQ. Dolphin's internal analytics showed that it had over 50,000 users in 2017. That number is likely substantially higher as of 2023, at a zero maybe. Now Moony, I can hear you ask, can Dolphin just take Nintendo consoles, remake them, and then release them for free? Isn't that illegal? Well, I'm glad you asked. You always ask the best questions, you know? Let's talk very not so briefly then, about the legality of emulation. You might be surprised to hear this, but the law around emulation is not nearly as settled as you might think. If you enjoy using emulators or are plugged into the dialogue around emulation, you might have heard that emulators are legal. I might have even said as much in another video. And a quick search online seems to confirm that. Every non-lawyer source states in their articles on emulation that emulators, the console mimics, are legal, but ROMs, the game mimics, are not. Let me ask you though, what are emulators legal pursuant to? In other words, it's great that everyone believes that emulators are legal, but why are they legal? What is the basis for their legality? Well, there's no act of Congress protecting emulation. There is no Supreme Court ruling protecting emulation. And we've seen how even Supreme Court rulings aren't exactly ironclad protection. No, emulation is protected by a single precedential ruling in the Ninth Circuit Court of Appeals that is now over 20 years old, a ruling that merely interprets a narrow clause in the DMCA, Sony Computer Entertainment Incorporated versus Connectix Corp. Connectix Corporation was a software and hardware company, notable for developing Virtual, a hardware device that introduced virtual memory to Mac OS many years before Apple itself would do so. In July of 1998, Connectix began development of the Virtual Game Station, a PlayStation emulator for Macintosh consoles. To create this Virtual Game Station, Connectix reverse-engineered the PlayStation's BIOS firmware, commercially releasing their emulator in January of 1999. In response to the emulator's release, Sony filed a complaint alleging that Connectix had violated Sony's intellectual property rights, including but not limited to copyright infringement. The lower court, the district court, initially held in favor of Sony, awarding Sony an injunction that blocked Connectix from copying or using Sony BIOS code to develop their emulator, and from selling the emulators they had developed. Connectix appealed the ruling, however, and the Ninth Circuit ruled 3-0 in favor of Connectix, a great result for emulation, surely. But here's the kicker. The scope of the ruling was pretty narrow. Here's what the Ninth Circuit ruled, and take note of this, as this is arguably the strongest legal framework we have to support the legality of emulation. In other words, this is it, the court's argument in consideration of each of the elements of fair use. Number 1. The nature of the copyrighted work. How much copyright protection does PlayStation actually have? Well, PlayStation firmware, and thus we can assume other console firmware, falls under a lesser degree of copyright protection that allows for examination and use of the examined code. In other words, you can look behind the curtain, see how the PlayStation is put together code-wise, and copy parts of it, but not the whole thing, to make something of your own. Number 2. The amount and substantiality of the portion used. How much and how often did Connectix use infringing copyrighted materials? Well, pursuant to number 1, the answer is none. PlayStation has a lesser degree of copyright protection, thus the code pulled from examination of the console and used is not infringing. As such, the final product contains no copyrighted infringing material. Number 3. The purpose and character of the use. What was the copyrighted material used for? Well, if the court already says that your console has a lesser degree of copyright protection, and that as such there is no infringement, the best argument you can make here is that Connectix infringed upon your copyright by making intermediate copies that were infringing while working on the non-infringing emulator. The court held that making said intermediate copies prevented wasted effort, which is one of the very purposes of fair use. In other words, nothing was wrong here either. And finally, number 4. The effect of the use upon the potential market. How badly does this emulator affect Sony's business and/or the market at large? Well, the court found that since the Virtual Game Station emulator allows for PlayStation games to be played on a Mac, the competition presented by Connectix is legitimate. In other words, although Sony seeks control over the market for devices that play games Sony produces or licenses, the copyright law, and I quote, does not confer such a monopoly. And if you recall the Sega video, you might remember what aspect of intellectual property does confer such a monopoly, the answer to which is patents. But we'll get to that later. The court also touched briefly on a trademark issue in this case, noting that the Virtual Game Machine trademark did not substantially dilute the PlayStation trademark. So that was a pretty dense section. Let's break that down into its simplest terms. This ruling allows you to reverse engineer a console to make an emulator. It allows you to use, but not completely copy, copyrighted BIOS software in the process. And this ruling allows you to sell that emulator without infringing upon a trademark. Now, a few of you in the audience might have been quite confused when I cited to Sony v. Connectix as the single foundation for emulator law, as there is a lot of mistaken understanding that emulation protections actually derive from a different Ninth Circuit decision in Sony versus Bleem LLC. Bleem is somewhat famous, after all, for winning an emulation lawsuit versus Sony, isn't it? Well, that lawsuit really didn't touch very much upon the legality of emulation itself, even though emulators were implicated. And the Bleem case cites directly to Connectix, stating, and I quote, "We have already ruled that the emulator is not a violation of the copyright law. See Connectix." So what happened? Well, in 1999, Bleem LLC developed an emulator that made it possible to play PlayStation games on a standard PC. To advertise the difference between the Bleem emulator and the PlayStation, Bleem utilized screenshots to advertise the same scene displayed on a PlayStation, hooked up to a TV, and the Bleem emulator on the PC. The PC emulator, not unlike Dolphin and the GameCube, was able to run the PlayStation game at a higher resolution, thus allowing for a much more impressive screenshot. The side-by-side comparison was then used in advertising. Sony sued Bleem over the use of the screenshots, not over the creation of the emulator, and the Ninth Circuit would find that Bleem's use of screenshots was fair use. However, where this case gets interesting isn't in the legal precedent that it sets, but in the social precedent that it sets. The outcome of the lawsuit is not the only way to hurt a party using the law. Bleem was able to crawl away from the victory against Sony over the advertisements, but just barely. It's one thing to take a case to the district court, and it's another thing entirely to appeal such a case and take it to the Ninth Circuit. These kinds of legal proceedings are extremely expensive, maybe not to Sony, but to Bleem it absolutely was, and Bleem's sales weren't nearly enough to cover the cost of legal proceedings. Sony then went in for the killing blow, filing another lawsuit, this time accusing Bleem of unfair competition and patent infringement. And while this was happening, with Bleem having to defend their patents to the tune of $1 million in legal fees per patent, Sony was attempting to obstruct Bleem's development of more games for their Bleemcast emulator, and was threatening to pull their own products from retailers who dared to stock Bleem products. The legal pressure built to a breaking point, and despite Sony never winning a lawsuit against Bleem, Bleem shut down in November of 2001. The last vestige of Bleem to go was their website, upon which they displayed a picture of Sonic the Hedgehog tearfully holding a flower next to a Bleem gravestone. A very sad sight. That was also later removed after Sega, ironically, threatened to sue. So in the midst of all that law and analysis, did you manage to understand what is legal, what isn't legal, and what still remains unclear? Well, let me break it down for you in the clearest and simplest terms that I can. For emulators, it is legal to reverse engineer an emulator pursuant to fair use. You can make copies of software for development purposes too. You can ostensibly play a game for a console you legitimately purchased on an emulator if the latter is also legal. And you can also sell an emulator if you do so very, very carefully. As we saw with Bleem, and we will see in a later example, even if you do everything right legally, you might still run into some opposition and you won't necessarily prevail commercially. It is illegal to reverse engineer emulators that use the whole code of the original console BIOS, and arguably also illegal to use an ill-defined, large enough chunk of that original console code. How much triggers that large enough is uncertain. And it is unclear as to whether it is legal to use an emulator even with legally owned software. In other words, it's legal to create an emulator by reverse engineering. It is illegal to create an emulator by outright copying code, and it is not legally clear whether you, the gamer, can use the emulator even with software that you physically owned and legally purchased. And for ROMs, it is legal to download and use public domain ROMs only. It is illegal to download and use so-called active ROMs, and here's where we dispel an enormous myth of emulation. It is not legal to play a ROM of an active IP game if you downloaded it, even if you own the game itself. If you downloaded the ROM or received the ROM from a friend and played it, you have broken the law. What is not as clear is whether or not you can make a backup of a game that you already own. Even that isn't necessarily legal. If you own a copy of, say, The Lord of the Rings, The Battle for Middle-earth 2, Rise of the Witch King, and you make your own backup copy of that game and choose to play it, that might be legal, but it isn't necessarily. If you downloaded the game but did not make your own copy, you have arguably broken the law as we currently understand it to be. But wait, I hear you say, what about the Digital Millennium Copyright Act? Wasn't the Ninth Circuit ruling of Sega vs. Accolade codified in the DMCA? Well, first and foremost, I'm impressed that you remembered all of that from the Sega video, but the answer is yes and no. The DMCA was codified in 1998, and it provides the language protecting reverse engineering to some extent. The Bleem case and the Connectix case both came after, in 1999 to 2000. And these cases distinguished this clause, 17 USC section 1201F. If you're curious, I'll link it in the description, and helped to clarify our understanding of this clause, but the DMCA itself contains no further assistance with regards to emulation per se. To make a long story very short, emulation, much like a lot of intellectual property law with regards to video games, is almost entirely unsettled, and relies on case law from a Ninth Circuit ruling that was decided in the same year that TLC released its hit single No Scrubs. It's a decision that is 4 years older than MySpace. So now you know the law, but you know more than the law. You also know the conditions of the law, which is to say, you can see how the entire edifice of emulation law hangs precariously on the cliff of these vague interpretations of 20-year-old decisions. With this understanding, we can now take a closer look at what the legal stakes actually are in this conflict between Nintendo, Dolphin, and Valve. In March of 2023, the Dolphin project developers made a surprising announcement. Their emulator would be coming soon to Valve's Steam service in Q2 of 2023. The announcement also made its way to Steam in the form of a shop page for Dolphin, which provided the projected release date and noted that the Dolphin app does not come with games, and that you must own an original copy of any game you want to use with Dolphin. The announcement was accompanied by substantial skepticism. Some commentators stated what seemed to be obvious, that Nintendo would not take Dolphin publishing an emulator on Steam lying down, and that some action against the release must be forthcoming. Others, however, seemed adamant in their belief that the laws surrounding emulation would protect Dolphin from a cease and desist. After all, given the common understanding of emulation law, what would Nintendo's argument be for a DMCA takedown or cease and desist anyhow? Well, on May 26, 2023, around 2 months after Dolphin's Steam release announcement, Valve's legal department received a short but very carefully worded letter from the law firm Jenner & Block, LLP, representing the interests of Nintendo of America. And on May 27, 2023, this interaction comes to light. Dolphin updates its website blog stating that Dolphin's release on Steam has been indefinitely postponed. Dolphin's team further states that they were notified by Valve that Nintendo has issued a cease and desist, citing the DMCA against Dolphin's Steam page, and that they removed Dolphin from Steam until the matter is settled. The team continued by stating that they are investigating their options and will have a more in-depth response in the near future. The wording of this blog post immediately raised a lot of conjecture. Did Nintendo go so far as to issue a DMCA takedown to Valve? Is Valve cooperating with Dolphin to quote-unquote investigate their options and formulate a response? There was some enthusiasm in the discourse. Would Valve and Lord Gaben wage war on Nintendo for the good of the people over this emulator debacle? Well, on or about May 28, 2023, PC Gamer claimed to have seen the legal notice received by Valve's legal department, and immediately they brought some interesting things to light. First, the letter was, in fact, more in line with a cease and desist and not a formal DMCA takedown. And second, we learned from PC Gamer's reporting that Valve itself was the one who brought Dolphin's Steam release to Nintendo's attention. But why should we rely on PC Gamer's reporting, as good as it is? As friends of a lawyer, you get inside access, so please find in the description a full link to the letter. Let's break it down together. Dear Valve Legal Department, I am an attorney with the law firm Jenner & Block LLP, etc. I thank you for bringing the announced offering of the Dolphin emulator on Valve's Steam store to Nintendo's attention. So within that first paragraph, we can corroborate PC Gamer's reporting. It was Valve who rang the alarm bell and brought Dolphin's attempt to publish its emulator to Nintendo's direct attention, clear as day. Let us continue. The Dolphin emulator is a piece of software that emulates games designed exclusively for Nintendo consoles, so the games can be played on other platforms such as Microsoft Windows, Mac OS, and Linux, such as the Valve Steam Deck. So we can see here that Nintendo was directly concerned with the emulator making its way to the Steam Deck via Steam. Now, the hacky types among you may already know that it is not terribly difficult to install an emulator onto a Linux-based device like a Steam Deck. But Nintendo's concern isn't you hacky types, it's giving access to this emulator to the general public, which we can now see more clearly. Moving on, the developers of the emulator have put up a coming soon page on the Steam store with a stated plan to ship the software in Q2 2023. As set forth below, and pay attention to this part very carefully, the Dolphin emulator violates Nintendo's intellectual property rights, including but not limited to its rights under the Digital Millennium Copyright Act, anti-circumvention and anti-trafficking provisions, 17 U.S.C. Section 1201. We provide this notice to you of your obligation to remove the offering of the Dolphin Emulator from the Steam store. So there it is. Nintendo claims that Dolphin violates Nintendo's rights pursuant to the DMCA. You may remember 17 U.S.C. Section 1201 from our discussion just now of the Connectix case, which touched specifically upon the topic of reverse engineering pursuant to 17 U.S.C. Section 1201F. Nintendo is claiming a broader scope of intellectual property violation that rests upon law which isn't very settled. Reverse engineering is legal as per Connectix, but how legal is distribution of an emulator? Well, that isn't as settled. It's also not Nintendo's chief argument, and we can see in the very next paragraph what Nintendo really intends to argue. And I quote, "The Dolphin Emulator is designed solely to play Wii and Nintendo GameCube games. Nintendo owns or exclusively controls copyrights in Wii and Nintendo GameCube games and authorizes third-party licensees who develop thousands more. Nintendo authorizes these games to be played solely on their native consoles. To protect Nintendo and its third-party licensees' copyrighted works, Nintendo places certain technological measures on its consoles and games. These include, among others, encryption on Wii and Nintendo GameCube consoles and games that effectively protect it against access to and copying of the copyrighted games, and inherently, the ability to play those games on an unauthorized console." And so this is very interesting. Nintendo is arguing not that the act of making or reverse engineering an emulator is illegal in their interpretation as per Connectix and 1201F. Nintendo is arguing that Dolphin's behavior is a violation of 1201A, violations regarding circumvention of technological measures. We've seen this kind of language before in the Sega video, when we discussed Sega vs. Accolade, how Sega was the first company to fire a broad shot across the bow of emulation but missed, and in the Nintendo Point Crow video, where we specifically discussed circumvention of technological measures with regards to mods. Sega vs. Accolade is the progenitor, the precedent upon which the Connectix case and large parts of the DMCA are built upon, but it's also case law from 1992, and technology has changed very substantially since then. Let's continue with a letter. Wii and Nintendo GameCube files, or ROMs, are encrypted using proprietary cryptographic keys. The Dolphin Emulator operates by incorporating these cryptographic keys without Nintendo's authorization and decrypting the ROMs at or immediately before runtime. Thus, use of the Dolphin Emulator unlawfully circumvents a technological measure that effectively controls access to a work protected under the copyright 17 U.S.C. Section 1201A1. So it is just as we predicted. The argument is in fact pursuant to 1201A, which avoids the emulation is legal arguments that emerge from Connectix and 1201F. And the specific issue at hand involves the use of cryptographic keys. In Sega vs. Accolade, Accolade prevailed over Sega in a similar situation. Accolade was reverse engineering Sega cartridges to get around Sega's licensing fees, and Sega didn't like that. Sega implemented a code-based security system known as the TMSS. Accolade was able to reverse engineer that code and utilize it to overcome the security system. The court in the Accolade case touched upon Accolade's circumventing of Sega's security system using reverse engineered code while it was conducting its overall fair use analysis. These are the 4 criteria of fair use. Number 1, what is the nature of the work? Number 2, what is the amount of the copyrighted work used? Number 3, what is the purpose of the use? And number 4, what are the effects of the use on the market for the work? The court in Accolade found that the nature of the work was overwhelmingly original content, that the amount of copyrighted work used, the TMSS code, was very small, a mere 20 to 25 bytes of data compared to the 500,000 to 1.5 million bytes of the full game, that the purpose of the use was limited to reverse engineering, and that the impact on the market was thereby limited. Can you spot the difference, though, between the Accolade case and the Dolphin situation? The court in Accolade was reviewing the entire act of reverse engineering a cartridge to circumvent the TMSS. As, to put it very simply, Sega sued pursuant to the entire act of Accolade making unlicensed but functional cartridges. Let's look at Nintendo's wording very carefully to see the cleverness therein. Yes, Nintendo includes its perspectives on all of emulation when it says that Dolphin is designed solely to play Wii and Nintendo GameCube games, and that Nintendo owns or exclusively controls copyrights in said games. However, the legal basis for the cease and desist is extremely limited in scope. What is the scope? Let's go back and read it again. Wii and Nintendo GameCube game files or ROMs are encrypted using proprietary cryptographic keys. The Dolphin Emulator operates by incorporating these cryptographic keys without Nintendo's authorization and decrypting the ROMs at or immediately before runtime. Thus, use of the Dolphin Emulator unlawfully circumvents a technological measure that effectively controls access to a work protected under the Copyright Act. Nintendo isn't making the argument that the emulator is an illegal act of reverse engineering. Nintendo is completely circumventing the reverse engineering issue that caused Sega to fail against Accolade, and Sony to fail against Connectix. Nintendo is dodging the 1201F trap. Instead, Nintendo is arguing only that Dolphin's use of the encrypted keys is copyright infringement, not protected by fair use, as the use of these specific encryption keys can only be used for circumventing technological measures that Nintendo has put in place. But wait, there's more. This paragraph continues, stating, distribution of the emulator, whether by the Dolphin developers or other third-party platforms, constitutes unlawful trafficking in a technology that is primarily designed or produced for the purpose of circumventing a technological measure, pursuant to 17 U.S.C. Section 1201A2A. This argument here puts Valve on the hook. If you publish this emulator on Steam, you are trafficking in a technology designed to circumvent a technological measure. In other words, you are distributing our encryption codes, and that's a violation of the DMCA. Let's continue now towards the end of the letter. The technological measures on Nintendo's consoles and games are essential for Nintendo to protect its intellectual property from piracy. When those measures are circumvented, Nintendo and third-party game developers suffer tremendous harm, because, for example, individuals can then use the emulator to play pirated games. Other commercial platforms have recognized these concerns, and as an example, we understand Microsoft recently took various emulators, including Dolphin, off its Xbox store. In this paragraph, Nintendo corroborates our understanding, but also offers another interesting tidbit, and that is this. There is industry solidarity against emulation. We've seen Sega stumble against Accolade, and Sony stumble against Connectix. At the time, the other developers were interested in the outcomes of these cases, but there was very little cooperation. Now, however, the situation is totally different. Microsoft, Sony, and Nintendo might be competitors, but they are all united against emulation. The final paragraph of the letter says this: we specifically request that Dolphin's coming soon notice be removed and that you ensure the emulator does not release on the Steam store moving forward. Pay close attention to this next sentence. This letter is not intended to be a complete statement of Nintendo's legal position or the relevant facts and law, and nothing contained in this letter is intended to or does constitute a waiver of any rights, claims, remedies, defenses, or positions of my client. The letter ends by noting that Nintendo is happy to discuss in more detail if any questions arise. This letter gives us some hints, as we discussed, about what Nintendo's legal theory might be if the emulator issue is brought to court. Before we close our discussion of the letter, though, let's do something together that you may have never done a single time in your entire life. Let's read the footnotes. Aside from Nintendo arguing that Dolphin's use of Nintendo's encryption keys constitutes a violation of the DMCA pursuant to 17 U.S.C. 1201A1, Nintendo also argues that Dolphin violates subparagraphs A2B and A2C, as well as each parallel provision in Section 1201B1. This isn't anything too new, but it does show us more of the legal framework being developed here. A2B states that no person shall traffic in any technology that has only a limited commercially significant purpose or use other than to circumvent a technological measure, a definition that an encryption key fits pretty well. And A2C states that no person shall traffic in any technology that is marketed by that person for use in circumventing a technological measure that effectively controls access to a work protected under this title. Remember, Nintendo's scope is limited to the encryption keys here, and as such, this could potentially be a very, very strong argument against Dolphin. But there's one little tiny nasty surprise in this letter, and it is in that same footnote. I don't think anyone has really picked up on this yet, but it stood out to me like a flashing red alarm. Nintendo requests that Valve retain backup copies of anything removed, and retain any communications Valve may have received or does receive from the Dolphin developers. See Federal Rule of Civil Procedure 37E. Rule 37E. I'll read some of it out loud for you. Rule 37E, failure to preserve electronically stored information. If electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it and it cannot be restored or replaced through additional discovery, the court, we can skip the rest. Here comes the bitter pill. You'd only request for a party to retain backup copies pursuant to FRCP 37E if you anticipated legal action of some kind. Maybe it's just due diligence, but maybe not. Now, before we move on from the letter, let's summarize that enormous block of legal analysis. We now understand the following. Number 1. that much of the law around emulators is unsettled. Number 2, that the protections that emulators do have are largely limited to reverse engineering. Number 3, that Nintendo issued a cease and desist and not a formal takedown. Number 4, that Nintendo's reasoning behind the cease and desist is designed to not be snared by the reverse engineering protections, is operating in that legal gray area for emulation and has a strong chance of succeeding. And number 5, that Nintendo is making preparations for a potential litigation in some manner. So we've talked about emulators and Dolphin, and we've talked about Nintendo. But there's still one party here whose motives we haven't discussed yet. And that party is Valve. Valve is a pretty unique company. Whereas Nintendo and Sega and Sony are publicly traded companies and thus accountable to shareholders, Valve is not. Valve is privately owned, meaning that you cannot freely buy and sell shares of Valve. In fact, it's widely speculated that greater than 50% of the company is owned by a single person, Gabe Newell. I say speculated because we don't actually know, and we don't actually know because Valve is private. But Valve isn't that special, I can hear some of you say. Isn't Epic Games also privately owned and running their own digital distribution platform? Well, yes, Epic isn't publicly traded, and Tim Sweeney allegedly owns greater than 50% of Epic. But unlike Valve, which we speculate is largely owned by its employees, Epic is accountable to outside investors. Epic has gone through at least 12 rounds of funding, raising $6.4 billion in capital from investors like Sony, who owns 5% of the company. And 40% of Epic is also owned by Tencent. So yes, Valve is quite unique in terms of its corporate ownership, but is it also unique in how it does business? In other words, if Valve is majority owned by Gabe Newell, is not accountable to big investors like Tencent, and Gabe Newell has a generally consumer-friendly mentality, can we count on Valve to act in consumer-friendly ways, or even take up the emulation banner and bring the fight to Nintendo as was anticipated by certain commenters? The answer, as we saw in Nintendo's letter, is an unequivocal no. But why? It makes sense for Valve to support Dolphin, doesn't it? Valve surely has a lot to gain from having emulators readily accessible on the Steam Deck or for use on PCs via Steam. And emulators ostensibly hurt Valve's competitors. If you're playing a game using an emulator via Steam, you aren't playing a game on your Nintendo Switch. Why did Valve ring the alarm bell for Nintendo if it doesn't appear to have anything to gain? Let's see what Valve itself has to say with regards to the questions above. On or about June 1st, 2023, Valve issued a statement to The Verge, stating the following, in part, "We don't want to ship an application we know could be taken down because that can be disruptive to Steam users. Given Nintendo's history of taking action against some emulators, we brought this to their attention proactively after the Dolphin team announced it was coming soon to Steam. Based on the letter that we received, Nintendo and the Dolphin team have a clear legal dispute between them and Valve can't sit in judgment." Let's look at that last sentence again. Valve sees that Nintendo and Dolphin have a legal dispute, and Valve doesn't want to sit in judgment. It wants to be neutral. But Valve has already sat in judgment, right? By number 1, contacting Nintendo, and number 2, taking down Dolphin in compliance with the cease and desist that it all but requested. What this letter teaches us is that when push comes to shove, Valve will not side with emulation. And if you understand why, it makes complete sense. The reasons why are tied to business ethics and corporate governance. Valve might be Gabe and Gabe might be Valve, but you only get to be a multi-billion-dollar corporation like Valve by making multi-billion-dollar corporation-like decisions. Let me rephrase that. When a corporation is formed, the core, the heart of the corporation is its business purpose. If you own a small indie game developer, your business purpose might be make the best video games ever. But as a corporation grows, inevitably, the business purpose of the corporation will shift to profit maximization. This can sometimes be avoided by smaller corporations, but even with very idealistic leadership, a corporation has certain obligations. Obligations to its clients or consumers, obligations to its employees, obligations to its suppliers or its distributors. And these obligations necessitate growth. Once a corporation grows large enough, it needs to continue to grow in order to meet the obligations that it has, which then causes additional obligations which requires more growth. Gabe is an idealistic man, but he is still a billionaire, and you don't get to be a billionaire without maximizing some profit. Here's the simple mathematics. If you take Dolphin and all of emulation and you put it on one side of a scale, and we call that what is Dolphin worth to Valve, and on the other side of that scale you put Nintendo, and maybe Microsoft, and maybe Sony, and all the other developers, and call that what is Nintendo worth to Valve, the scale falls heavily on the Nintendo side. You see, although Valve doesn't really do any business with Nintendo, it could. Nintendo's been moving in an increasingly cooperative direction. The passing of Nintendo's developer-led old guard has given way to business-savvy new leadership, and Valve sees that there is a lot of money on the table. It is in Valve's interest to cultivate a positive business relationship with Nintendo in the long term, as it is a massive potential area for growth. Dolphin, on the other hand, being a free emulator and a legal flashpoint, offers almost nothing at all in comparison. There's another factor to consider here though, regarding why Valve chose to side with Nintendo, or at least chose to side against Dolphin, and that is this. Emulation is an existential threat to the entire video games industry, and it is in the interest of the entire industry to fight against it. What do I mean by this? Consider for a moment what emulation represents, or for that matter, what the free software movement or the open source movement represents. The disconnection of digital property from capital. Remember those "you wouldn't download a car" advertisements? Well, imagine if you could, for free. You'd expect all the car manufacturers to be up in arms about it, right? A world where emulation is legal, ROMs are legal, and video games are open source is just such a situation for companies like Nintendo, Sony, or even Valve. It is no wonder that Valve, with its glorified DRM digital storefront, sides against emulation. However, there is yet another layer to this entire story, and that is the concept of legal brinkmanship. As you may recall, the law surrounding emulation is very flimsy and ill-defined. Emulator makers generally choose to lay low to avoid any negative attention from big companies, like Nintendo. And Nintendo doesn't want to tackle the emulation issue in court only for the court to open the law even further, perhaps granting legality to ROMs, or clarifying a legal gray area to the detriment of Nintendo. And so there has been an uneasy peace. Nintendo still deeply believes that emulators are illegal, and it has every incentive to prove that they are, as does Sega, as does Sony, as does Microsoft, as does Valve. However, nobody wants to push the big red button, because if you do, you may disrupt a status quo that is generally favorable for you. Sure, you could win, but how big of a hole is emulation in your profit margins really? Emulation is an existential threat, but not a meaningful present danger, and so it can be somewhat ignored. The cost of losing and having the DMCA expanded to include protection for ROMs, perhaps, is enormous, potentially industry-destroying. And so even if the chance of the big corporations losing the legal battle over emulation is slim, they have kept away from pushing the big red button, as the risk is not generally worth the reward. There have been some close calls though, where matters regarding emulation were nearly brought to court. Take for example, and I bet you didn't see this coming, the story of the Soulja Boy console. Soulja Boy is a Chicago-based rapper, notable for being off Init-O. In late 2018, Soulja Boy released a series of video game consoles dubbed the Soulja Game Console and the Soulja Game Handheld, respectively. These consoles were essentially hardware emulators with access to PlayStation, Neo Geo, PC, Sega, and Nintendo games. The news of these releases was shocking. How on earth did Soulja Boy manage to pull this off? Did he really get permission from Nintendo to make a console like this that mixes Nintendo and PC and PlayStation games? Many people at the time were very skeptical and wondered aloud whether a lawsuit was forthcoming. Soulja Boy replied to that skepticism as follows, and I quote, "For anyone that thinks Nintendo is going to sue me, you're retarded." He continued by stating, "Nothing's going to happen. Everything is legit." But as it turns out, not everything was indeed legit, and Soulja Boy ended up pulling his console due to an impending enormous lawsuit from Nintendo, a lawsuit that could very well have been a push of the big red button. The latest news on the Soulja Boy console alleges the existence of a Soulja Boy game 2.0 of some kind that released in 2023, but information on that is scarce. So where does that leave Dolphin, Nintendo, and the big red button? Well, Dolphin broke the unspoken rules of engagement. You keep your head down, we look the other way, and we maintain the status quo. In response, Nintendo has armed the big red button. Now Nintendo has a decision to make. Does it accept that Dolphin is adequately cowed and put away the button? Or does it make an example out of Dolphin and threaten the button to shut Dolphin down, but potentially risk having to push said button to make good on their threat? I think Nintendo and Valve, for that matter, would strongly prefer the former. Dolphin, though, isn't accountable to shareholders, nor beholden to growth, which makes it very unpredictable. I will say this, though. For anyone itching to fight, Nintendo has a very strong, carefully constructed argument, and they've been preparing for this fight for 2 decades now, a fight the emulation community isn't even aware it's fighting. If Dolphin chooses to escalate and the button is pushed, it may very well mean the end of emulation. So think carefully and choose wisely. The law surrounding emulation is balanced on a very precarious cliff, and the industry is waiting with open jaws below for the final push to happen. The big red nuclear lawsuit button is on the table and the glass has been lifted. Nintendo has made it clear to us all that they are ready to go all the way. Valve has also made it abundantly clear that they are not willing to step up to the bat for Dolphin. Quite the opposite, they're tacitly on Team Nintendo, as is the rest of the industry. A return to the status quo antebellum may be in the interest of both sides here. Dolphin can chug quietly along, trying not to make too much of a splash, and Nintendo can put away the button and turn its focus towards other, more pressing matters, like Soulja Boy. The community that has sprung up around emulation is truly remarkable, like a little patch of pristine meadowland in a sea of industry gray, protected by the thinnest little bubble of law. The question remains, do we try to expand the meadow through the asphalt, or do we focus on preserving our precious, endangered sanctuary? The choice, ultimately, is up to you. I've been your host, Moony, and thank you for tuning in to Moon Channel. So long and thanks for all the games. So sad that this is where it came. We tried to warn you all, but oh dear. When you mess with the company's intellectual properties, make sure you are prepared for retaliation. So long, and thanks for all the games. Dolphin's about to be destroyed. There's no point getting all annoyed. Lie back and let the matter resolve. If you have ROMs you'd like to play, watch out for the DMCA, or you might find yourself in lots of trouble. And so long, and thanks for all the games.